How long will your Florida divorce take? A few weeks, a few months, a few years? The choices you make really affect your timeline. And in this video, I'm going to show you how to make one that move your case along. Waiting is one of the hardest parts of divorce. It's the not knowing that keeps you up at night. If that's you, take a deep breath. You're not behind. You just need a clear map. I've got you. I'm Vanessa Vasquez de Lara, founder of the Vasquez de Lara Law Group here in Miami, the firm that makes lives better in and out of family court. Sometimes that means bold representation, but often it means simple, smart steps that save you time and stress. Most people think there's a standard divorce Florida timeline. You file, you wait, a date appears, everyone gets the same pace, right? Not quite. We've seen thousands of divorce cases in my 20-plus year career. Some take just a few months. Others drag out for longer than 2 years. So what's the difference? There's a theoretical minimum for how long a divorce will take. You can't just show up to the courthouse and get it done the same day like a Las Vegas wedding. Florida law sets a short waiting period of at least 20 days from filing before a judge can sign your final papers. And if you have kids, you both have to have an approved parenting course within 45 days of filing before everything can be finalized. But realistically, it's going to take longer than that. How much longer comes from your process and your preparation. And a big factor that we can't control is the court and the judge's schedule. There are a limited number of judges and a limited number of spots in their calendars. So here's what we're going to cover in this video. I'll give you real-world time ranges for uncontested, collaborative, and contested cases. I'll walk you through each stage so you know what actually happens after you file. I'll explain discovery so you can see why it can add weeks and sometimes months to your case if it's messy, and I'll share 7 simple moves that shave weeks, sometimes months off your case. And know that I'm only talking about Florida divorces, and this is informational, not legal advice for your particular case. With that clear, let's talk about the one choice that has the biggest effect on your time and your schedule. Your process, uncontested, collaborative, or contested. Choose your path, choose your timeline. The more things you agree on, the more time you're going to save. Fighting always adds time, most likely months, to your case. So work with your attorney to pick the best path for you. In an uncontested divorce, you both agree on all the major terms and sign the paperwork. When the forms are clean and the parenting course is done, many Florida cases finish in about 30 days. That window largely depends on how quickly you both sign and how soon the court can give you a short final date or how soon they're going to review the paperwork to just sign off. If you go collaborative, it means you use a problem-solving team instead of fighting in court. You meet, you trade documents, you make decisions together, and you keep it private. Most families who go this route finish in about 90 to 180 days because meetings are easier to schedule than court hearings, and you control the pace. Contested means a judge has to decide on things, and that can add so much time. There are motions, formal requests for information, and multiple hearings before any trial. That's why contested cases often take anywhere from 9 to 18 months or more. It's just a process. It's more steps, more calendars to align, and more waiting. And remember, these are typical Florida ranges, not promises. Now let's walk through what comes next and why each step takes the time it does. Think of this like a roadmap, not a script. You may move faster on some parts and slower on others, and that's okay. First, you've got pre-filing preparation. Plan on 1 to 4 weeks for smart prep. Taking a little more time here will help us save months down the road. You gather the basics. Pay stubs, bank and credit card statements, tax returns, retirement balances, mortgage releases. If you have kids, we sketched a parenting plan so we're not starting from zero. If you and your spouse already agree on most terms, we put that in writing so that it's clear. Next is going to be filing and service. This is when we file your petition with the court. Your spouse is formally served, which means they receive official papers from a process server or the sheriff. This step usually takes 1 to 3 weeks, depending on how quickly your spouse can be served. They'll have 20 days to respond to the court. And even if they're served day 1, we have to wait for the mandatory 20-day waiting period after filing before a judge can sign anything. And if you're going the collaborative route, we actually wait on this step. We contact the other side and do all the discovery and negotiation before we file the divorce petition with the court. Next is discovery and negotiation. This is the part that can take the longest. If you're going uncontested, it's typically pretty short. But if you're in a contested battle, both sides can really drag this out. Discovery is where both sides share the required information so everyone can make good decisions and work from the same facts. A big part of this is a financial affidavit. The rules expect this within 45 days of your spouse being served. But if things like bank statements and home valuations are missing or even just unclear, there can be a lot of back and forth between your attorneys. If someone is slow to respond, the other side may send formal requests. If the request is ignored, the court can set a hearing and tell the other side, you gotta comply. But those hearings take time to schedule. And that's why discovery can stretch a case 4 months. At least in our firm, we often try to negotiate and with the other side and settle on as many things as possible before mediation. But unfortunately, not every side wants to make things easy. The next stage is mediation. Ultimately, this is where most contested cases are going to settle. In an uncontested case, you already agree. You don't really need mediation, and we move to final paperwork. In a contested case, courts usually require mediation before any trial, especially in Miami-Dade and Broward. Scheduling depends on everyone's calendars and the mediator's availability. A focused, well-planned mediation session can replace months of fighting. Mediation can either be all-day talk or same-day progress. If we go in with a written agenda, a fair range for each issue, and 2 or 3 workable options, there's a good chance we can reach an agreement here and put this case to rest. That brings us to the last stage, the final hearing or trial. If your case is uncontested, your collaborative agreement is done, or we settle during mediation, the final hearing is short and simple. But if your case is still contested, that means we're going to have to go to trial, and you can literally wait months before a trial date. Sometimes even a year. And that means we just have to wait and pray nobody files a continuance, which is a formal request by one side to reschedule the hearing or trial. There generally has to be a good reason, but I've literally seen cases wait months for a trial only to have it rescheduled. But even if both sides do everything right, no one is stonewalling and no one files a continuance, one thing still affects your pace that's beyond ours or the other side's control. The court's schedule. 2 families can do the same things and still finish on different dates. Every county's court moves at a slightly different pace. Every judge moves at a different pace. Some have more cases. Some have fewer judges. That changes how fast you can get a spot. Each judge also keeps a schedule for certain days and certain types of hearing. Think of it like a doctor who only sees new patients on Tuesdays. If you're a new patient and the first open Tuesday is next month, you're going to have to wait. Holidays are always going to slow things down. School breaks slow things down. Bad weather can close a building with hurricane season. Sometimes it could push a week of hearings into the next week or even the next month. Experts and mediators have their own calendars too, and we need everyone to match. Here's the empowering part. You cannot control the court's calendar. You can control your speed. Answer messages quickly. Sign forms the same day when you can. Say yes to the first available date that works. Be open to morning slots and virtual appearances when the court allows it. Little choices like that keep you moving while the big calendars catch up. So let's talk about how to make your divorce move. You don't need magic. You just need a few smart habits that stack. Here's 7 of them. 1, pick the right lane early. If you can agree, stay uncontested or use a collaborative team instead of a court fight. That skips long lines for hearings and trial dates. It's like the express lane on 95. It doesn't guarantee you'll get there faster, but you'll generally be moving a lot quicker than everybody else. 2, make one clean file folder of all your financial documents. Pay stubs, bank and credit card statements, tax returns, retirements, mortgages, leases, any loans. Label the files, PDF only, no pictures. When everything's in one place, we don't waste time chasing just one more statement, and the court doesn't set a hearing just to ask for paperwork. 3, agree on a number when you can. House value, car value, small business value. Use one appraiser both of you trust and accept. One appointment and one report beats 2 experts, 2 schedules, and a long debate. 4, take the parenting course early if you have kids. Do it while we gather documents. Keep the certificate ready. Judges can't sign the final papers without it, and we don't want your last step held up by a missing class. 5, treat mediation like a working meeting. Bring a short agenda. For each issue, bring a range and 2 or 3 real options. If you get stuck, ask the mediator for a simple, written middle ground to react to. Clear choices turn talking in circles into, we have a deal. 6, keep messages cool and short. Use the 24-hour rule for hot text. Don't send it right away. Stick to dates, times, and simple asks. Calm notes lead to quick yes or no answers. Hot notes lead to long letters and emergency hearings. And 7, say yes to the first good date. Morning slot, great. Video appearance, even better. The earliest openings go to people who can take them, and that might be you. Just 2 or 3 of these can save weeks, and sometimes even months from your divorce. That's how you get out of waiting and back into your life. Now, before we wrap, let's do some rapid-fire review questions. Can I get divorced in a few weeks? Technically, yeah, but it's usually at least 6. And that's if it's truly uncontested, you don't have assets and debts to split, and no kids. If we have kids, does that slow us down? Not if you agree on everything and take the parenting course early. The back and forth around the kids is usually one of the biggest roadblocks. But when those pieces are ready, your case keeps moving. Do we have to wait for a trial to finish our divorce? No, you can settle anytime, even before mediation, even the day before trial, although I don't recommend it. A signed agreement turns a long trial date into a short final hearing. Will filing lots of motions and being aggressive push things faster? Sometimes a motion is needed. A motion is just a written request for the judge to decide one issue. But each motion needs time to write, time to schedule, and a hearing to talk to the judge. So no, filing motions on everything is just going to slow things down. Can we skip the paperwork to save time? Nope. There are basic levels of paperwork that go into any divorce, even if you DIY it. If you try to skip the paperwork, it's just going to drag your case out. No. All this talk about timelines might have you wondering if you're even ready to move forward with a divorce. Well, I have something for that too. It's our divorce readiness quiz. I built it to feel like a conversation, not a test. Answer honestly, and you'll get a much better idea of things you should be thinking about to be truly ready for a divorce. Tap the link in the description or the pinned comment. Just click the link in the description, and remember, it's just informational, not legal advice on how to handle your specific case. When you're ready to get advice specific to your situation, call my office or schedule a case evaluation on our website to speak with my team. So now you know the Florida divorce timeline and how it works. Let's keep your momentum. Next up, we'll tackle how custody and child support are decided in Florida in plain English. We'll cover who makes decisions for the kids, how time sharing gets set, and what goes into the child support number. Income, overnights, health insurance, childcare, the simple stuff that drives the math. I'm Vanessa Vasquez de Lara, the founder of the Vasquez de Lara Law Group, the firm that makes lives better in and out of family court. See you soon.